Hi, my name's Alex Dolphin and welcome back to another episode of Ex Ante. Today we're going to discuss the case Bob Jones University versus the United States. This case was heard in the Supreme Court of the United States in the year 1983. Let's go ahead and jump into the facts of the case. So Bob Jones University was a private school and it was a fundamental Christian school. Now what that meant in the 1980s was that they were opposed to interracial marriage. Okay, so now that we understand what Bob Jones University is, now we need to understand what a 501c3 is. So Congress enacted this portion of the U.S. Code, which created a tax exemption for charitable organizations. Now, charitable organizations are defined in the statute as organizations that are exclusively religious, charitable, scientific, testing, literary, or for educational purposes. So generally, private schools fell within the 501c3 classification because they were engaged in education. So therefore, they're a charitable organization as defined by statute. Now, the IRS, before this case, very recently, had changed the rules of what qualified as a charitable organization. And they said that any private school that discriminates on others on the basis of race is not a charitable organization, and therefore they are not 501c3s, so they're not tax exempt. Now, you can see how a university where tax-exempt status is a really big deal for them, why this would be an issue. So they sue the United States and said the IRS basically overstepped its bounds. It is not allowed to change the law like this so substantially. Congress had enacted the law to say that all organizations engaged exclusively in education are 501c3s. There's nothing about racial discrimination in there. So the IRS overstepped its bounds. So the court is left to either affirm the IRS ruling, which says that private schools that discriminate on the basis of race are no longer charitable organizations and no longer tax exempt, which would be a big hit for any of these religious schools that maybe oppose interracial marriage. So the Supreme Court rules in favor of the IRS and of the United States and says that this was well within the IRS's rulemaking authority to redefine these charitable organizations and education as only schools that don't discriminate on the basis of race. Now, their reasoning for this is a bit more on the purposivism side, and you can see that in the analysis and in the opinion written by Chief Justice Burger. That becomes clear because there is nothing in the text of the statute that talks about discrimination on the basis of race, but rather what there is in the text of the statute is a statement about how this is meant to foster charitable contributions and charitable organizations in the United States. And so what Chief Justice Burger says is with that word charity, we find the purpose of this statute. And charity he defines as charity is something that is in accord with the public policy. Now, the public policy of the United States, he says, it's been clear ever since the civil rights era, is to eradicate racism. And so anything that goes against that public policy of the United States is not charitable and therefore can't be defined as a charitable organization underneath 501c3. And so he says the IRS was correct to do what it did. So a purposivist argument on behalf of Chief Justice Burger. Now, Justice Powell concurs in the judgment, but his concurrence largely states that he rejects the reasoning in the majority opinion, and he rejects it largely because he says it is meant to foster diverse viewpoints, is what the charitable exemption is meant to do. And if we say that only things that are in accord with the public policy of the United States are charitable, then what we're going to do is we're going to basically disqualify tons of what we would assume to be charitable organizations from the 501c3 status. So he says this is a really slippery slope that we don't necessarily want to go down, but ultimately he does concur in the judgment, likely because of the case at hand is so heavy, it would be hard to rule that racial discrimination is okay, 20 years after the civil rights movement. So Justice Rehnquist does not find the arguments of the majority or the concurrence ultimately persuasive, and he writes a dissent. Basically, the crux of his consent is to say that Congress didn't change the law. If Congress wanted to change the 501c3 law to prohibit discriminatory private schools from being qualified as 501c3s, they certainly could have, but they never did that. And it's not our job as the judiciary to be changing the law. So Justice Rehnquist is largely, it is one, an intent argument, and then two, a textual argument. The textual argument being that, hey, there's nothing in the text about discrimination, and then the intent argument being Congress never intended to change this. Congress, when they enacted this 501c3, it didn't intend to do anything about racial discrimination. It was solely to promote education. He says, if Congress wants to change the law to outlaw discrimination, then they certainly could have, but they haven't. So that's the case. It's interesting because you see a lot of different views of legislative interpretation in one case. The argument of Justice Berger seems to be persuasive because a charitable organization is generally not one that is discriminatory. We don't find that. Ultimately, we find those two things in conflict with one another. The argument of Justice Rehnquist is also persuasive because the Congress never did anything. Is it really the job of the judiciary to change the law? And so the question becomes, does Congress need to change the law on everything, or if the general policy of the United States, as evidenced by the Civil Rights Act and subsequent acts trying to prohibit racism, is to get rid of racism, well, then should that purpose of Congress pervade the rest of the U.S. Code? I think that's an interesting debate, especially because of possible legislative inertia that comes with topics like racial discrimination. It's very hard legislation to pass, and at that point, should the judiciary just be a cooperative partner of the legislature and help them implement the public policy that Congress has made so clear that it's trying to implement in the United States? Now, I think it's also to think about legislative inaction. Is legislative inaction evidence that the Congress is fine with the statute as it is? And it seems like we should think that. But the other side of that argument would be, Congress can only do so many things. And if it makes clear its purpose through other statutes, maybe we ought to glean that purpose and the intent of Congress as it's placed into other statutes into certain areas of the code. Now that becomes a very slippery slope because then we have to figure out where we're going to draw the line. Is the judiciary really independent at that point? Is that going to give the judiciary too many opportunities to impart its subjective views on the law rather than the dutifully elected Congress? And I think that's an interesting question to think about as well. So thanks so much for watching. I hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button. And I hope you have a nice rest of your day. Bye-bye.